Hello and welcome. Today I will be discussing the good faith doctrine and whether the UK should adopt an idea of good faith in the performance of all contracts. Introduction. It is a question of whether the doctrine of good faith should be applied to all contracts, whether they be contracts that are held at arm's length or relational contracts or different specific types like employee-employer contracts. However, this presentation will try to demonstrate that a duty of good faith should be enforced only when expressly incorporated into contracts or if the context of the contract requires it. What is good faith? It is a generally undefined term, and many different jurisdictions, different court law systems have their own definitions for it. And it is a developing area of law. However, the general idea is that it's a standard of behavior for parties to behave in respect of their obligations to each other. It could be considered fair and open dealing. Firstly, I will deal with the attitudes represented in Yam Seng. Legat in Yam Seng famously stated that not for the UK not to have a notion of good faith was swimming against the tide. In that many other countries have adopted a general duty of good faith in all contracts, and the UK was out of step for not doing so. He proposes that good faith should be a general term of implied term of fact in all commercial contracts, stating that, in particular, the requirement that parties will behave honestly is so obvious that it goes without saying. Such a requirement is also necessary to give business efficacy to commercial contracts. I will deal with this later. Legat also specifies that what good faith requires is sensitive to context. That includes the core value of honesty. Many have criticized Legat's position of simply defining the duty of good faith to being honest. However, the emphasis on the importance of good faith in relational contracts is made very clear. However, he does not define what they are. Legat states that the difference, the dichotomy between fiduciary contracts and commercial contracts is too arbitrary and should be defined. There seems to be a limited impact following Yam Seng by the UK courts. They have generally rejected the idea of an implied term of good faith in all contracts. For example, in Hansard 3147 Limited, Norris J stated that I readily accept that there will generally be an implied term not to do anything frustrate the purpose of the contract, essentially stating that good faith can only be really implied as a duty of excluding bad faith. Furthermore, in Care Wash Care Services, the courts define the relationship to be a relational contract, however, refuse to imply a duty of good faith. So the general sort of current attitudes of good faith at the time is that there are not the English law does not recognize a general or implied duty to negotiate in good faith. This is sort of reasserted in Mid-Essex Hospital Services NHS Trust, and the approach of Legat and Yam Seng has generally been sort of rejected in a large part. Courts are, however, prepared to recognize an express provision for parties to act in good faith when the parties write that in their contract, but the scope of this duty is limited, as explained in Bristol Rovers. The attitudes of the UK courts on good faith on express terms. Express terms are allowed and can be enforced, however, they must be precise to be applied, as demonstrated by Bristol Rovers. Any express term will be interpreted carefully in the context of the entire contract and the commercial relationship between the parties. However, it is limited in its ability to regulate behavior, as it is usually only applied to being exclusion of bad faith. Physiotherapy. The need in relational contracts. There is an emergence of the notion of relational contracts in which parties within the contract need to work with trust and honesty. It's not generally defined, but it is recognized in Bates v. Post Office 2019 that good faith should be a term implied by law to relational contracts, and he goes on to define exactly what he believes should be considered in considering a relational contract, but it's not an exhaustive list. So I now go into possible consequences of good faith. The reasons against good faith seem to generally fall under two ideas: the desire for UK courts to avoid uncertainty and the need to preserve the freedom of the parties to contract, both important principles in UK law. So, firstly, it leads to uncertainty. Um, as good faith is not precisely defined in England or anywhere else, really, and also they struggle in different jurisdictions with uh, consistently applying good faith. It could lead to uncertainty in contracts. Uh, Furthermore, this idea is sort of extended by Ross Landsberg and Peter Medgens, stating that the possibility that in the international context, which the UK courts would be definitely within, good faith could mean different things in different cultures and backgrounds. And this is supported by Hesselink, as he describes good faith as a norm that depends on the circumstances of the case in which it is applied in different countries and by different cultures. This means that different parties from different places with different backgrounds would assume the duty of good faith to mean different things, and this also depends upon the period in which the contract takes place, as social norms change over time. Furthermore, there is the idea that good faith is a moral or ethical standard, as outlined by M. Bridge, that it is not for the courts to impose a moral and ethical standard because that is outside the scope of the law. In terms of commercial contracts and therefore parties acting and performing a contract wouldn't know what specifically the duty of good faith requires, therefore would not know specifically how to act. There is well also the idea that on a practical level, there are numerous different types of relationship that would have to be governed by the idea of good faith. And so there would be many possible additions of good faith that would have to be employed in these different types of contracts. And this is another challenge for good faith. How can there be a universal and general definition if it has to apply to many different, very specific contracts, such as fiduciary contracts or consumer contracts or employee-employer contracts? The second idea is that good faith might restrict the freedom of contract, and by imposing duties upon the parties that they did not intend, or imposing standards upon the parties to perform the contracts a certain way. The UK is a hotspot for contracts to be made in a certain regard, partly for its ability to allow freedom of contracts and its certainty. So changing this might influence the way that parties see the UK justice system. It is imposing a limit on self-interest. Could be said that it cuts against the essentially individualistic ethic of English contract law, as stated by R. Brownsword. This idea that parties have the right, if they want to act in their own self-interest and should not have to consistently think of the other party's expectations and wants. They might, to a certain degree, not have to do anything that would be illegal, such as fraud or misrepresentation or duress, but to act in their own self-interest when needed might be required and might be held to be okay by the other party. It could be said that duty of good faith is implementing an external standard of acting in moral ways by the courts. However, there is the argument that the court's not imposing the intention of good faith, but are rather reflecting the parties' intentions. Furthermore, it could be argued that good faith is already present in some degrees in UK contract law. Bingham Lord Justice stated that the UK has developed piecemeal solutions in response to demonstrated problems of unfairness. Basically stating that the UK doesn't have one general umbrella term, but has specific tools used to combat acting in bad faith. These solutions could be promissory estoppel, consideration, frustration, duress, fraud, mistake, representation. And it could be argued that by using specific terms in specific circumstances, the UK's approach, to a certain extent, more precise than the notion of good faith. And one of these duties is very similar to good faith. For example, the duty to cooperate is outlined in Mackey and Dick in 1881. There was a general purpose that any decisions that should be made with both parties in mind. Each agrees to do all that is necessary to be done on his part for carrying out of that thing, though there may be no express words to that effect. Should the term of good faith be implied by fact? Is it possible? In Marks and Spencer PLC, the test was restated to be: is the term necessary to make the contract work, and is it necessary to provide business efficacy? The GATT's view is that the requirement that the parties behave honestly is so obvious that it goes without saying. However, I suggest that it is not necessary to make the contract work. As many different contracts don't expressly require it and have different backgrounds and definitions of good faith, yet they still work. Furthermore, in Tor Asset Funding, Sales J made it clear that any proposed implied term must be able to be defined with precision. However, as we've discussed, good faith is not. Counterpoints. There is, however, the possibility that instead of negatively affecting certainty, a duty of good faith could create and improve certainty. The courts already recognize various implied duties in contracts, such as those mentioned before, mistake, representation, and by adopting a general rule, it would allow for many different rules and doctrines to be unified under one principle, therefore improving certainty by contracts and understanding what good faith actually specifically means. By expressly advocating against bad faith, self-interest, and exploitation, it might significantly increase willingness to form contracts by parties, especially when bargaining power is unequal, and it will provide the ability for those in better positions to also not choose UK law if they're both international parties in order to escape its good faith obligations. As previously mentioned, the notion of good faith in general can be seen underlying many areas of the contract law. Uncertainty is present in some degree in the UK law. For example, such terms as fairness, reasonableness, unconscionably, substantial, and these terms are implied. Therefore, good faith could be as well. Furthermore, the idea that good faith doesn't restrict the freedoms of the party, but rather just protect their reasonable expectations as outlined in First Energy UK Limited. And uncertainty is seen as somewhat necessary sometimes, so the courts can have a more nuanced approach to each case. Conclusion. The notion of good faith isn't unfamiliar and isn't alien to the English courts and lawyers. Therefore, implementing it might not be an impossible task, but might not be necessary. The precise implications of good faith are unknown, and how it would be applied by courts. This could be quite a significant impact if implied. However, it might lead to contractual uncertainty, and it needs to be defined, and the parameters of the duty of good faith need to be defined. And it poses a risk to the freedom of contract enjoyed by parties by presuming the intentions of them. If parties entering contract wish to uphold those duties of faith, however, they should expressly state this, and to the extent of the duty of good faith.